Under Section 113, a proof of cessation of territory. This section was enacted to exclude inquiry by Court of Justice into the validity of the act of government so far as cessation of territory to any Indian state was concerned. But the section is a dead letter that the Governor General in a council being precluded by 2425 and clause 67 of section 22 from legislating directly as to sovereign or dominion of the crown over any part of its territory in India, or as to the allegation of British subject could not be by legislative act purporting to make a notification in the Government Gazette conclusive evidence of a cessation of a territory, exclude inquiry as to the nature and the lawfulness of that cessation. The section is now obsolete. Section 113A, the presumption as to abatement of suicide by a married woman. The word having regard to all other circumstances of the case in this section give wide power to the court to appraise evidence and to come to a conclusion whether there was some extraneous cause for a woman to commit suicide. The words all other circumstances of the case require that a cause and effect relationship between the cruelty and the suicide has to be established before drawing the presumption. Therefore, the presumption is not mandatory nature. The mere fact that if a married woman commits suicide within a period of 7 years of her marriage, the presumption under this section would not be automatically applied. The term the court may presume, having regard to all the other circumstances of the case, that such suicide has been abated by her husband, would indicate that the presumption is discretionary. In a dowry death case, the presumption that suicide was abated by the accused husband of the deceased could be drawn only when a prosecution has discharged the initial onus of growing cruelty or initial onus of proving cruelty. In a state of West Bengal versus Oriel Jaiswal, it was held that the requirement of the proof beyond reasonable doubt in a dowry death case does not stand altered even after the introduction of section 498A of the IPC and section 113A of the Evidence Act. Although the court's conscience must be satisfied that the accused is not held guilty when there are reasonable doubts about complicity of the accused in respect of the offences alleged, it should be borne in mind that there is no absolute standard for a proof in a criminal trial, and the question whether the charges made against the accused have been proved beyond all reasonable doubt must depend upon fact and the circumstances of the case and the quality of the evidence adduced in the case and the material placed on a record. The doubt must be reasonable man, and the standard adopted must be a standard adopted by a reasonable and just man for coming to conclusion considering the particular subject matter. Under section 113B, presumption as to dowry death. When the question at the issue whether a person is guilty of a dowry death of a woman and the evidence discloses that immediately before her death she was subjected to such person to cruelty and or harassment for or in connection with any demand for dowry, section 113B provides that the court shall presume that such person has caused dowry death. Of course, if there is a proof of the person having intentionally caused a death, that would attract section 302 IPC. Presumption of a dowry death under this section has a purpose. It is beneficial provision aimed at giving relief to a woman subjected to cruelty routinely in an Indian household. The meaning to be applied to each word of this provision has to be in accord with the legislative intent. Even while construing this proviso strictly, care will have to be taken to see that its object is not frustrated. The presumption under this section is attracted only in a case of suicidal or homicidal death and not in a case of accidental death. Presumption under this section is a presumption of law on a proof of its essentials mentioned therein. It becomes obligatory on the court to raise a presumption that the accused caused the dowry death. While the word shall presume in section 113b mandates that the court is duty bound to proceed on the basis that the person has caused the dowry death, the presumption is rebuttable and it is open to prove that ingredient of section 304b of IPC are not satisfied. Section 113b of the Evidence Act being procedural, it has been held that it is retrospective in operation. In a case where a demand of dowry is alleged, such demands are confined with four walls of the house and known only to the members of both sides of the family. In such case, independent and a direct evidence with regard to occurrence is ordinarily not available. That is why the legislature has introduced a section 113A and 113B in Evidence Act by permitting presumption to be raised in a certain circumstances. Under section 114, the court may presume existence of certain fact. Section 104 to 113 directs on whom burden of proof will lie. The court is bound in every instance to presume against that party on whom the burden of proof is directed to lie. No option given to the court as to whether it will presume the fact or not. But there are various presumptions where room is left for the court to exercise its powers of inference. The court cannot throw the burden of the proof on whichever side it chooses. This section deals with cases of description. It declares that the court may, in all cases, whatever draw from the facts before it, or whatever inferences it thinks just. The term of sections are such as to reduce to their proper position of a mere maxims which are to be applied to facts by the courts in their discretion. A large number of presumptions to which English law gives to a greater or less extent an artificial value. 9 of the most important of them are given by way of illustration. The effect of this provision is to make it perfectly clear that the court of justice are to use their own common sense and experience in judging of the effect of particular facts, and that they are to be subjected to no particular rules whatever on the subject. The illustration given are for the most part cases of what the English law are called presumption upper law. Artificial rules as to the effect of evidence by which the court is bound to guide its decision, subject to, however, to certain limitation which it is difficult either to understand or to apply, but which will be swept away by the section 114 in question. A presumption is not evidence or a proof. It only shows on whom the burden of proof lies. The section authorizes the court to make the certain presumption of the fact. They are all presumptions which may naturally arise, but the legislature, by the use of the word may instead of shall, both in the body of the section and in the illustration, shows that the court is not compelled to raise them, but to consider whether in all circumstances of the peculiar cases they should be raised. The section does not lay down any hard and fast rule with regard to circumstances in which any fact or facts may be presumed to exist, nor does it contain an exhaustive list of such facts, though it gives a few illustrations from various walks of life. Under section 114A, presumption as to absence of consent in a certain prosecutions or rape cases. Evidence of bad character of an accused person is not relevant under this section for the purpose of raising a general inference that the accused is likely to have committed the offense charged. Such evidence is irrelevant and cannot be legally admitted in evidence, whether elicited by the prosecution or by the defense. This description of the accused as to lawbreaker amounted to evidence of a character the Supreme Court excluded a man's guilt is to establish by proof of the facts alleged and not by the proof of his character. Such evidence might create prejudice but not lead a step towards substantiation of a guilt. The prohibition does not in any way affect evidence which is required to prove a motive for the crime or which is otherwise relevant. But in assessing punishment, the court may take into consideration the accused's character and antecedent or the state of crime in a country or locality. Section 114A no doubt addresses the consent part of the woman only. When the offense of a rape is proved, but is also impliedly would be applicable in a matter where the victim girl had gone to the extent of committing suicide due to the trauma of rape, and it was sought to be disbelieved at the instance of the defense that she had woven a concocted story, even though she suffered the risk of death after consumption of poison. If this were to be accepted, then what was the need of incorporating an amendment by incorporating a section 114A, which clearly has been added to weight and credence to the statement of the victim woman who suffers the offense of a rape, and a kaleidoscopic interpretation of this amended provision cannot be made to infer that the version of the victim should be believed relating merely to consent in a case where the offense of a rape is proved by other evidence on record.